our guest this afternoon is a very patriotic and nationalistic Sierra Leonean, and he's doing a lot, and he's a ferocious learner. He not ever get enough. Ask him how many masters he has already. The pursuit of education has taken him from the European continent to the American continent, back to the United States. So that is why when he came, we've been trying to get him from his busy schedule to at least give the talk to inspire you. Because as I told you, guest lectures, that is why on your timetable you have periods that are meant for guest lecturers. That is not just what you learn in your civil procedure and everything, but when you listen to guest lecturers from their experience, their perspective of things, it makes you well-rounded learners. So he needs no introduction. All I can say, our guest lecturer this afternoon is Mr. Francis Benkefala. Esquire, he doesn't need an introduction. You all know who he is. He is the anti-corruption commissioner. I always tell you, if you want to be a lawyer, you have to be a fit and proper person. And he is one of those people that will scrutinize you if you hold public office, and once you fall into his trap, you will not be fit and proper. So, ladies and gentlemen, please rise up and let's welcome Francis Benkefala.
Thank you. Thank you. Thank you. All right, please have a seat. Please have a seat. So, my brother here, I usually call him and say I'm very proud of the work you are doing at the law school. Because when I became anti-corruption commissioner, one of the challenges I faced was the one that was constantly coming from the law school. Examination malpractice, problems with lecturers, grades, graduation issues. The law school was a constant headache. I did all kinds of reports, investigations. So, maybe it was coincidence. God was preparing me for me to have a good sleep. These days, I hardly hear any report from the law school. And that's because since he came in and became director, things have stabilized. And I'm not saying it because he's here, because I know. I know the reports that used to come on my table every day. I know students that used to come. We used to even send people to come and supervise law school exams. It was that bad. Leakages were everywhere. And above that, the administration itself was very, very chaotic. And we didn't want that for the legal profession. Obviously, with what I always say, this is the only country we have. We can go everywhere, we can do all kinds of things. But there is no such feeling as when you are back in your country. And above that, we all have a responsibility to make it work. Nobody is coming. If this man had not come back to be director here and to stabilize things, trust me, the reputation of the law school was so bad. But that cannot happen without all of you. I'm sure your presence here, you all will help maintain that. Not so? Yes. We pledge, not so? Yes. Good. All right. I'm here today to bother you a little. To have a little conversation about issues. My lectures are designed not to teach law. They are designed to open your eyes and minds to things about the law. So if you think that I'm here to teach you law, you are making a mistake. I'm not here to teach law. Your professors and lecturers are doing that adequately. Yesterday I was teaching at Fabric College, lecturing at Fabric College, and it's the same thing I told them. They thought I was joking. But by the time the lecture ended, they knew exactly that I was there to tickle their minds about obvious things that they have not been seeing the way it is, but it is very important to them. So I'm here today to have a conversation with you, and when I say a conversation, it is indeed a conversation. Because I'm sure by the time I finish teaching what I'm teaching, you are going to have so many questions in your mind that answering them is going to be challenging for all of us. But that is the point. I'm here to leave you with more questions than answers. So, I told him that we were going to do comparative judicial politics. The idea behind it, I don't want you to be surprised as I was surprised about the courts, about justice, about judging. And these are things that traditional teaching, what I am about to tell you today, are things that traditional legal teaching will never tell you. So we have lawyers who behave like they are zombies. They live in a bubble because their training prepares them not to accept certain things as facts, as true, even though they see it. So, I'm about to open your eyes to a few things. And today, this lecture has been designed around courts. 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 What are courts? As a lawyer, if they ask you what is a court, what would you say? Someone? A place where disputes are resolved. But there are many places where disputes are resolved, which are not necessarily courts. Not so? Examples are what? Mediation, arbitration. Not all these other ones, not so? So, he's right when he says court is one of the places where disputes are resolved. Now, the foundation of courts is from the Roman Empire. The Romans, kings were so busy with things because how the primordial human development happened is every petition had to go to the king. Justice was the king. It was the king who had to settle disputes between citizens. Even in our traditional settings today, when things happen not so, they go to the chief. So it was not different from these other societies before the Roman Empire, where everything had to come before the king. But the population of the world at that time was small. People lived in very small communities. When you hear some of those places, they tell you, for example, the kingdom of X. Let's say they say the kingdom of Sweden or the kingdom of Denmark. Probably the population of the entire kingdom of Denmark could have been at that time the population of one village in Sierra Leone. So it was easy to go before the king and petition everything. But then, as things would develop, it became that kings cannot hear every dispute because there was so much population. So, what the Romans developed was that when you have your problems, you identify somebody who you believe can solve that problem, and you go before that person, and then the person settles your dispute between you and you are bound by it. So what does that mean? What is the heart of what I just said? What is the heart of you and somebody agreeing on somebody to settle your dispute? What is at the center of it? Mediation, yes. What else? Trust. What else? Conflict resolution, yes. There's a key word. Agreement. Consent. So court started based on what we call consent. once her and her agree that Ben Kaifala will be their judge in a particular land dispute matters, whatever decision that Ben Kaifala passes, both of them are required to obey. Do we understand? As time went by, this consent, because imagine having all these little tribunals everywhere. Imagine Sierra Leone today, every time we have a dispute, we have to agree on somebody, and somebody has to come and sit down and determine the issue, and we are bound by it. And we have somewhere where we have a registry where we have to go and register our dispute. And if one person does not agree to it, the state can come in and force that person to agree because there was consent. Could it work? So, as things developed, consent was replaced with law. Consent was replaced with law. The state came in and made laws and said this is what should happen, this is what should happen. And laws include what? Substantive law and procedure. So the law now came and removed that ability of two people to agree among themselves, which was very primordial or which was very primitive, and substituted it with law. Law became the consent. First of all, do you agree that law is consent? Do you consent to every law in Sierra Leone?
You voted.
You want to agree that I have just said that your ability to agree with someone else and say we trust Ben Kaifala to be our judge was removed by the state and replaced with the state saying this is what the law says, you are bound by it. When you have a dispute, you go to the magistrate court. Or you go to the high court. If you are unhappy, you go to the court of appeal. Did you consent to that? Good. So we are starting the conversation because this is really what I want. And I don't have an answer for you. So, the state now substituted consent to mean you have agreed that you will go to the magistrate court. I don't remember giving that agreement. But there's nothing I can do about it. If somebody goes and occupies my land today, and I still feel like I can agree with somebody to do it, I can still go ahead and do it. But if the other person does not agree with it, the state is not coming to force the other person to go ahead. Because the state has said when you have this dispute, go to the high court. Now, what it means, the state now developed what we call a triadic dispute resolution system. Triadic, where you have party A and party B who are unhappy with themselves, and the state pulls party C, who is the judge to hear and determine that dispute. Why did the state do that? Why did the state take away your ability to decide for yourselves how your issues should be settled? In fact, it turns out that there are other means of still doing it. We have mediation also. We have negotiation. We have arbitration. We have all other means. Of all these different sets of settlement of dispute, the most coercive is this triadic dispute settlement system. The most coercive, the one which is forced down your throat, is the one that we lawyers are trained to go before. The most lacking consent is this one. Because if you look at mediation, who knows how mediation happens? It's a very simple process also. Both parties have to agree who is their mediator. If they do not agree, the mediation will not happen. It's only when they agree that the mediator will come in and then decide. Arbitration, same thing, not so. Both parties have to agree on the arbitrator or a group of arbitrators. If they do not agree to it, it's fine. The most brutal form of justice dispensation, the most coercive, forceful, is the triadic dispute resolution system that has a judge, party A and party B, who, after having their disputes, have no choice, have to go before this judge to settle it. Now, let's go back and examine how does this judge get here. At the center of the triadic dispute settlement system is the fact that two parties who have a dispute have to identify somebody who is independent, who has no interest in the matter, to hear the disputes and resolve in favor of one person. And that resolution is justice. Not so? That is what the triadic dispute settlement says. That is what, whenever I use triadic dispute, just say courts. Because it's basically saying there's an independent judge sitting here and the two parties have a case, they go before him or her, and he or her will determine the case based on fairness, on justice, as the case presents. Now, firstly, this judge was imposed on them. And there is no way they can say the judge is fair. If you even believe that the judge is the most dishonest judge, and sometimes we know this, we lawyers, we know dishonest judges. Parties to a case know dishonest judges. They know, for example, when they were at law school, this man who's today is a judge was the biggest spy sitting by him. Why should I go before him to hear my case? But what the state does to all of us is to impose that judge on us. And in most cases, we don't have a choice. Yet, that is the foundation of the triadic dispute resolution system. But then let's even assume that he's an honest judge. Let's assume he's a man of good pedigree. He came to law school, was top of his class. He's lived his life very normally and has now become the judge of Sierra Leone. And you have a case that says the state versus, what is your name?
Francis.
Versus Francis. You have a case that says the state versus Francis. Now, by show of hands, how many people say that this conforms with this triadic dispute resolution system? How many people think that The state versus Francis. Francis is before an independent person. Nobody? Nobody believes that when the state says the state versus La Joanna is not before an independent person in this class. Then why are we here? But it is interesting for me to know why you are refusing to vote that this conforms with this. Somebody just tell me. Why? Why?
There's a presumption that the state is an extension of the bench.
The state is an extension of the bench. So the state is representing the bench. And therefore, when you have a matter against the state, you are actually appearing before the state. Doesn't that scare you?
It does.
Yet, the core foundation of traditional legal tutelage is what? What is the core foundation of traditional legal teaching? Yes. It's not far away from it. Separation of powers, yes. What else? Fairness. Judicial independence. When we are taught in law schools, from those who come from Unimark, Frabe College, Jala, those who have come from various universities in England and across the world, what you were really taught was that the foundation of all of this is that don't worry, just become a lawyer. You are going before an independent judge to hear the dispute between your party who has stolen millions and the state. And that judge is independent. Do you agree? Do you agree? Yes. All right, I want to hear those who say it depends. Let's hear what is it depends. Do you agree that the judge is independent? Yes, sir. That is why we are having a conversation. I told you people, I want us to have a quick conversation on this. Yes.
Yes, because he has been put in a position of trust. And we look at him to be somebody very fearless, and someone who's independent of political parties.
Yes, but is he?
Yes. I mean, people have different views.
No, I want your view.
Yes.
Yes. Yes. You cannot answer this question by telling me he's independent. You have to explain to me why you think he's independent. Or because he has been put in a position of trust, therefore he's independent?
No. Because, I have to be one. Because of what his role is supposed to play.
Yes.
In that case.
Yes.
So, we look at him to be somebody independent.
Because of the role he's about to play, so we look at him to be somebody independent. My question to you is he independent? I'm not asking you how you look. I'm asking you, is he in actual fact independent? When they say, your client is now John Cisse, JS, and this judge is representing the state, sitting down in that court for that trial against John Cisse. And he stands there and the clerk takes, in the matter against John Cisse, now Mr. Joseph Cole presiding. Is Mr. Joseph Cole independent?
Yes.
Okay, let's hear him. Yes.
Yes, I'm looking at it from the normative perspective.
Normative, yes?
Yes, normatively, it should be, because normatively you follow you look at it as it is, rather than as how it ought to be.
Okay.
Now, when you look at the judge from a normative perspective, he's supposed to be independent, regardless of whatever the circumstance is. And he is also supposed to be fair
Yes.
regardless of all the circumstances.
Yes.
Well, by practice, he studied law
Okay.
and he read law,
Yes.
which means that he's supposed to exhibit the empirical aspect of it.
Yes.
So
Is he?
He is independent.
He is. Thank you. Yes. Let's take the last one there.
Yes. To me, by virtue of
By virtue of his office.
he is supposed to be.
Yes, you are using a lot of suppose, but the question is a very practical one. Is he independent?
Yes.
I am not talking about what ought to be. I am saying, what are you seeing with your eyes? Is the state against justice and the judge is sitting down there? Is that judge independent of the state?
He's independent.
Yes, thank you, thank you. Now, who thinks that he's not independent? Let's hear a lady. Yes, madam. Give it a try. Don't worry. Look, let me tell you something. Those I taught at Fairbank College understand this. You can say anything in my class, and there's nothing wrong with it. Okay? Yes.
I'm not sure it's facts, but
It doesn't have to be facts.
okay, thank you. What I'm saying here is that compare and contrast between the United Kingdom and when someone offends the state or have a case against the state, the judge is independent. However, the administration under the constituency will sat with the judge whilst the person examined with the offender. Does that make sense?
No, I did not understand it.
You're asking if someone has a case.
Listen! Allow her to speak.
If someone has a case against the state, right? You're asking, the question is if the judge is independent.
Yes.
Fine. The judge is independent. However, there is a constitution that governs when the judge is coming to do the
Work. When they coming to do the work, yes.
I think it's going to have the administration with some other judges.
Okay.
Just to not to be biased or forget about the juries. But
Okay.
the judge has to have some
All right.
backups as
Okay.
an administration.
I get your point.
Thank
All
you.
right, okay. Now, fundamentally, you can see already that even when we are sitting down there, even those of us who are saying that he's independent, we are speaking more in terms of ought than is. So that is already a tacit admission that we agree, or we can see clearly that there's a problem here. We can see that there is a problem here, but it is that problem that traditional legal teaching ignores. And because the traditional legal teaching ignores that problem, when lawyers become lawyers, they are shocked when they stand in court and they see certain things happening. So, let's take first of all the constraints. The pre-constraints to the appointment of a judge. This very law which has been imposed on you, which you don't have a choice of, says what? That he's appointed by the president and approved by parliament. Oh, you are saying it is a joke? The appointment of the judge is by parliament. So even a pre-constraint, first of all. A lot of you here are going to become lawyers, and by all degree, you are amazing people. You want to become judges. I can assure you, if the president doesn't like you, you are not going to become a judge. No matter how Sierra Leone loves you, you are never going to become a judge. In fact, if you are not careful, you wake up one morning and you see an announcement. The man who used to come to class last and leave first and spends 5 days does not come to class. Even the pass at law school, the law school had to change the rules for him to go. They say, let my people go. And you wake up that morning, all of you were in this class. Suddenly, either this man is the president's friend, the president's brother, the president's uncle, or he's a big party man. He is the new judge of Sierra Leone. And in fact, if you are unlucky, if you are extremely unlucky, you wake up to an announcement that he's the Chief Justice. So, the pre-constraint in terms of appointments comes from the state. And let me tell you, I used to be a very naive lawyer. I was an activist. There are times when I would hold the justice system to ransom. Things like judicial independence, rule of law, separation of power. The way I was fed in law school is the way I assumed it to exist. Sorry, I am doing some work for the state. That's it. Therefore, there are pre-constraints to appointment which make it impracticable for this man to not become a lawyer. So there are those pre-constraints, but let's also look at the post-constraints. Who pays the judge? Who pays the judge? The state pays the judge. And what do they say about he who pays the piper? And these are all things that are visible in our eyes, but we choose not to see them. But even more visible, how many of you have gone to High Court number 1? How many of you have gone to High Court number 1? Yes, you worked in the court, not so? Where is Kanu? And Kanu, please stand up. Where the judge sits in High Court number 1, what is above the head of the judge? And Kanu, please be quick. What is above the head of the judge in High Court number 1? The coat of arms, the emblem of the state. So, what I'm teaching here is an entire course. So maybe we'll explain and sometime we'll introduce it in the law school. Courts, comparative judicial politics is an entire course of its own, so I cannot go in certain details. But I'm here to teach your minds to start thinking around these things. I don't want you to make the mistakes that many lawyers do. And that is why they appear, sometimes you're sitting down, you look at them, you're asking yourself, what is wrong with this man? So, there are post constraints and there are what? Ex ante constraints. When the man is appointed, his salary is provided by the state. It's the state that gives him the car that he drives. It's the state that designates what building he sits to do cases. It's the state that determines how long he can remain as a judge. It's the state that makes sure his welfare is taken care of. Yet, we refer to the case as triadic. Now, I don't want you to be very sad. It is not all a tragedy. Now, the purpose for which courts were created, primarily in the Roman Empire, was not to administer justice. Courts were part of the administration. In fact, in the Roman traditional judging system, the word magistrate is an office, and it is not a judge. And that is what the civil law offices still do today. And that is why they do not even accept the adversarial system. They sit down there, yes, what is happening? Yeah, you, what is happening? Yes, I think I find in favor of this part. Is that quick? All the French countries, that is what they do. The magistrate is the inquirer. There is nothing like when we sit down and say, hey, Mr. How are you? What is your name? Can you tell this court where it's come from? I am putting it to you that you are not. They don't have that. It's the magistrate who asks the questions and after that takes the decision. They are not that naive. The magistrate is the representative of the state. He's acting on behalf of the state. So, the question then is, what was the purpose of the courts? And I can tell you this, whether you dispute it or not, whether you agree or disagree, you can always argue this amongst yourself. But the purpose of courts was to maintain social order. The purpose why courts were created was to maintain social order. In England, for example, the king wanted to understand what is happening in the realm. So he sends judges and magistrates to different parts of the country to represent the king. In Roman Empire, when you hear they say the prefectorate of Judea, where Jesus Christ was born, that there was a certain magistrate there called Herod. Herod was a representative of the king. And his role there was to settle disputes among people where the state did not have an interest. And that is where the triadic dispute settlement system works. It is not every case that goes before the court that the state has an interest. It is not every case that goes to courts that the state has an interest. John and his brother are fighting over a land. The state does not care who wins. There is where the judge should be independent. Because really that is now triadic, not so? It's two people against one man who has no interest in the case, not so? Here, the state versus Francis, there is no independence. And there is no independent, the prototype court is an independent judge sitting in an independent court with two parties to a dispute who have no connection and interest to him, appearing before him, and he decides based on the justice and fairness and facts of the case and nothing else. It cannot happen here. But that does not mean justice cannot happen here. But the only thing why I am lecturing here is for you people, first of all, to cancel out that thing of independence you have in your mind, that they have put so much in your head. Justice may happen here, but to say that that is an independent place, you are making a serious mistake. But in the case of him versus him before the state, it is triadic. But even there is a problem. Because when the state is not interested does not mean the judge is independent. Because the state is not interested does not mean the judge is independent. Because where the state interest has been removed, SI, there is also called social interest, another SI. And there's another one called PI, personal interest. In fact, there's another one called OI, other people's interest. So, firstly, we create the bubble. State interest, the state has no interest. When the state has no interest, we go to SI, social interest. If you go before a judge and he is a fuller man, and this judge has a proclivity of protecting fullers, you are in trouble. If you go before a judge and he's a Mendy man, and this man is a Mendy tribalist, before even you start opening the law books, he has already decided in his mind that the other tribes are all crooks and criminals. You are in trouble. Social interest, which has nothing to do with the state, by the way. And the judge, whether you believe it or not as a lawyer, the judge will determine that case based on that his prejudice. And he's not independent. Personal interest. Believe you me or not, there are cases where judges have personal interest. It may not be very obvious. It may be completely not obvious. But when they decide that case, that their personal interest will override them. It may be that that personal interest was just that one man came before him with a very beautiful woman. And his desire is, after judging this case, for the woman to... His personal interest is going to be substituted. And there are even other people's interest. And other people's interest is the same as personal interest. If I am judging a case because Emma Hamilton is my friend, and I don't want to hurt Emma Hamilton, and I therefore decide the case, having that in mind, and because of that I am not willing to rule in favor of somebody who clearly has justice on his side, that personal interest is my interest. And I am not independent. So, in the bubble of independence, by the time we narrow down all those little interests, you find out that there is very little room for anything called independence. And sometimes these things are before us, but we refuse to accept them as lawyers. But when you truly study courts and how judges behave, when you look at the structures of the court, when you look at everything, what that gentleman said, normative independence does not exist. Normative independence is the most useless thing. What really you should watch out for as lawyers is not what those laws say. The laws are coercive parts of the state. They have substituted consent. And when they have substituted consent, they create all kinds of theories. Theories like, you voted your members of parliament, therefore wherever they say, is you saying it. And we agree. But it is no different from the money in your pocket. When the state says that paper is money and it is worth 100,000 euros. And we agree. These are the little things that cloud our minds. These are the little things that cloud our focus. But, like I said, the reason why I am giving you this lecture is to prepare you as lawyers to navigate yourselves in a very complex world. The world of judging. The world where judges are strategic actors. So sometimes the case goes before the court and you think that the facts are so clear, yet the ruling goes the other way. And you ask yourself, the This is so clear that you do not even need to be a lawyer to know. Why? Judges are strategic actors. And the system has been created by the state in such a way that strategic decision making is protected. For example, in the US, why do you think when they are appointing judges in the US, the argument is not about how qualified or unqualified they are? What is the argument? Is he a Republican or a Democrat? Is he a conservative or a liberal? And there are many other cases. The constitutional cases that go to court. Elections are over. You go before the judge and say, Judge, the man is already president. They have sworn him in 3 days ago. And you come before this judge for the judge to rule that the man is no longer president. I am not here to break your zeal. I came here to give you questions in your minds. And I want you all to have conversation around everything you've had here today. It will guide you as you become lawyers. It will give you your sanity. But above all, it will show you how to make money in a complex world without being dishonest to yourselves. Mr. Director, thank you very much for this opportunity. Maybe a few questions.